The United States Supreme Court has just dropped a bombshell emergency ruling that is sending shockwaves through the entire political and legal landscape. This is not some minor procedural order. This is a massive, high-stakes intervention in the American election system, one with nationwide implications that could reshape how congressional maps are drawn, how Voting Rights Act challenges are handled, and how much authority states actually get to keep when it comes to running their own elections. And while the outcome itself was significant, many legal experts are saying the language inside this ruling may be even more important than the result. Because buried inside the order was a direct message, a signal aimed at every lower federal court in the country, a signal about who controls elections in America, a signal about how far courts can go when intervening in election-related disputes as voting deadlines begin to approach, and a signal that the era of last-minute judicial rewrites of election rules may be coming to a hard stop. So let's break this all down. Exactly what the Supreme Court said, the pointed rebuke they delivered to the lower courts, the key legal principles driving the decision, and what this means for redistricting battles in election law heading into 2026 and beyond. To understand how we got to this breaking point, you have to understand the conflict that brought this case to the Supreme Court in the first place. This entire firestorm centers on a series of lower court challenges that were testing the limits of the Supreme Court's own recent landmark precedents on redistricting and the Voting Rights Act. Following clear guidance from prior High Court decisions, several states moved forward with their congressional maps for the upcoming election cycle. These were maps drawn by elected legislators, accountable to the voters, balancing communities of interest, incumbency, regional ties, and all the traditional factors that go into fair redistricting. But predictably, activist groups rushed into friendly district courts arguing these maps violated the Voting Rights Act or the Constitution. And in at least one major case that bubbled up to the emergency docket, a lower court panel didn't just rule against the state. They issued a sweeping injunction that would have forced massive last-minute changes, including court-drawn alternative maps that conveniently favored one political side. Meanwhile, election preparations were already underway. Ballots were being finalized. Election workers were being trained, timetables were being implemented, and every day that passed deepened the administrative chaos this ruling was creating. That kind of intervention is exactly what the Supreme Court had been warning against. The lower court essentially ignored the High Court's own directives, treated legislative disagreement as evidence of bad faith, and rushed to insert itself into the election machinery at the worst possible moment. States appealed immediately, filing emergency applications straight to the Supreme Court, arguing that this lower court defiance was not only legally wrong but practically disastrous for election administrators and voters alike. The Supreme Court answered loud and clear. In a sharp, no-nonsense order, the majority granted the emergency stay, instantly restoring the maps and procedures the states had lawfully put in place. But they didn't stop there. They went further than many expected at this stage, explicitly stating that the states have a high likelihood of success on the merits. When you hear that language from the Supreme Court on an emergency application, it is not subtle. It is a strong indicator of where the final ruling is headed, and the opinion that accompanied the stay took the gloves off entirely, calling out lower court judges for defying recent Supreme Court precedents, ignoring foundational legal principles, and meddling in the middle of an active election cycle. Let's walk through the key pillars of the court's reasoning, because this is where it gets critically important. The first major pillar was the presumption of legislative good faith. The Supreme Court reminded everyone that when state legislatures draw maps, those maps carry a strong constitutional presumption that elected representatives were acting in good faith. The lower court in this case had essentially flipped that presumption on its head. They treated the state's continued defense of its map, after years of litigation, as supposed evidence of discriminatory intent. The Supreme Court called that fundamentally wrong. Legislators are entitled to the presumption that they acted in good faith. You cannot assume racism or partisan malice simply because the outcome was not what the plaintiffs wanted. This part of the ruling is especially powerful because it protects the democratic process itself. State lawmakers, not federal judges, are the ones accountable to voters. Undermining that accountability opens the door to judicial legislation, which is precisely what this court has been working to rein in. The second major takedown focused on the proper application of the Voting Rights Act framework. The Supreme Court has been crystal clear in recent precedents. Race cannot dominate over traditional districting principles. Challengers bringing a vote dilution claim must show an alternative map that satisfies all legitimate state interests just as well as the enacted map, not just on racial metrics, but across all traditional criteria. In this case, the plaintiffs simply did not meet that bar. The lower court ignored the state's strong interests in preserving historic communities, particularly economic regions along the Gulf Coast, keeping county lines intact and avoiding unnecessary incumbent pairings. The special master map forced by the lower court actually performed worse on these traditional criteria while chasing racial targets. The Supreme Court called that error out directly. By rejecting that approach, the justices reinforced something critical. The Voting Rights Act is not a tool for racial engineering or proportional representation by race. It is about preventing actual vote dilution, not manufacturing specific electoral outcomes. This has massive implications for every state currently fighting similar Section 2 challenges. Texas, Georgia, Louisiana, and others now have much stronger ground to stand on. The court is effectively telling lower courts to stop using the VRA as a blank check to redraw maps for political advantage. Third, and perhaps most urgently for the 2026 election cycle, the court doubled down on the Purcell Doctrine with unmistakable force. Named after a landmark Supreme Court case, this long-standing principle holds that federal courts should be extremely reluctant to change election rules close to an election because of the massive chaos it creates downstream. Election systems are incredibly complex. States spend months preparing ballots. County officials organize polling locations. Voter information materials are distributed, deadlines are established, and once those systems begin moving, even relatively small legal changes can create enormous logistical problems. The lower court tried to sidestep Purcell entirely by claiming their court-drawn map had been operating smoothly. The Supreme Court rejected that argument outright. They emphasized that states themselves, as sovereign entities, get to decide whether changes are feasible and in the best interest of their voters. Federal judges do not get to override that judgment lightly. The opinion reinforced state sovereignty in powerful terms. While federal courts must exercise caution with last-minute changes, states are free to implement and adjust their own lawful maps as they see fit. That is a direct rebuke to the kind of judicial overreach we have seen in certain district courts in recent years. This part of the ruling is enormous in its reach. It draws a bright line and tells every federal court in the country, stop interfering in the middle of an election cycle unless there is an absolutely compelling reason. That warning has ripple effects far beyond this one case. Of course, the decision was not unanimous. The three liberal justices, Sotomayor, Kagan, and Jackson, issued a lengthy and sharply worded dissent. Justice Sotomayor took the lead, accusing the majority of injecting chaos into the process and essentially rewarding what she described as continuous gamesmanship by the states. She argued that restoring the state's preferred map would force election officials to scramble, reassign hundreds of thousands of voters, and create confusion at the worst possible time. The dissent painted a picture of smoothly running court-drawn maps from previous cycles and suggested the Supreme Court was ignoring practical realities in favor of ideology. But notably, the dissent spent relatively little time engaging with the majority's core legal points about the presumption of good faith or the proper VRA framework. It focused more on practical disruptions and policy outcomes, while the majority pointed out clearly that the real disruption comes from unelected judges overriding elected legislatures at the 11th hour. Now let's talk about what this ruling actually means moving forward, because the nationwide implications are only beginning to emerge. Election disputes are no longer isolated events. What happens in one jurisdiction quickly becomes a blueprint for litigation everywhere else. Attorneys study successful legal strategies, state governments monitor judicial decisions, advocacy groups examine new precedents, and before long the same battles reappear in courts across the nation. Many analysts believe that pattern is already unfolding here, because the questions raised by this emergency ruling about election administration, judicial intervention, and state authority are not unique to one state. They exist everywhere. Right now, several battleground and southern states are navigating similar Section 2 challenges. The Supreme Court's strong language here about presuming legislative good faith and applying the correct VRA framework gives those states powerful new ammunition. Lower courts in those jurisdictions are now on notice. If you try to override a legislature's map with a special master's judicially engineered alternative, especially close to an election, the Supreme Court is prepared to step in fast on the emergency docket. In the state at the center of this emergency application, officials are already moving full speed ahead. Voter rolls are being updated, district boundaries re-established, and communications going out to candidates and county election boards. This restores certainty for everyone involved, something the lower court's injunction had ripped away. And because the Supreme Court signaled a high likelihood of success on the merits, this momentum feels durable. Reactions are already pouring in from across the political and legal spectrum. Constitutional scholars are calling this a meaningful reaffirmation of federalism and the proper limits of judicial power. They argue the Supreme Court has begun reining in a pattern of judicial activism that has plagued redistricting for decades. On the other side, advocacy groups are framing this as a threat to minority voting rights and promising additional litigation. Justice Sotomayor's dissent is already being treated as a rallying document in those circles. But here's what the legal terrain actually looks like after this ruling. The era where plaintiffs could present a map hitting certain racial targets and automatically win in federal court is under serious pressure. The era where district judges could issue sweeping injunctions changing election rules weeks before a cycle begins without consequence is facing a hard challenge from the highest court in the land. And the principle that elected state legislatures, not unelected federal judges, should be drawing the lines that define congressional representation is being forcefully reasserted. Looking ahead legally, the next major step is almost certainly a petition for writ of certiorari. With this strong stay order in hand, the states are in prime position to ask the Supreme Court to take up the full case on the merits. That would allow the justices to issue a definitive ruling, one that locks in these protections nationwide and establishes clear standards for how these cases are handled going forward. If granted, and the signals suggest it very well could be, we could see a landmark opinion that defines redistricting law and federal court authority for the rest of this decade. That is the bigger story underneath this emergency order. Major constitutional disputes rarely end with a single ruling. They evolve through multiple rounds of litigation. Each new lawsuit raises different facts, different arguments, different legal theories. Eventually, those disputes build toward a much larger showdown, and many analysts believe election law is currently moving in exactly that direction, toward a defining moment where the Supreme Court will be forced to answer the fundamental question at the center of all of this. Who ultimately controls election administration in the United States? The Constitution gives states a central role in conducting elections. At the same time, federal courts possess authority to enforce constitutional protections. For generations, those two principles have coexisted, but when disputes arise, tensions inevitably surface. How much discretion should states receive? How much oversight should federal courts exercise? And where exactly should the line be drawn? Those questions remain unresolved. But what is no longer in doubt is that the Supreme Court is paying close attention, moving quickly when it sees lower courts defying its own precedents and drawing clear lines about how far judicial intervention can go when elections are already in motion. For now, one fact stands undeniable. The court acted. The court moved decisively, and the court delivered a ruling that is already reshaping how election law professionals, state officials, and federal judges across the country are thinking about the battles ahead. Whether viewed as a victory for state sovereignty, a warning to activist lower courts, a reaffirmation of federalism, or the opening chapter of a much larger constitutional fight, this emergency decision has instantly become one of the most closely watched election rulings in years. But the story is far from over. New cases are emerging, new challenges are being filed, and the constitutional questions at the center of those disputes are nowhere close to fully resolved, which means this ruling may ultimately be remembered not as the final word, but as the moment the Supreme Court made unmistakably clear where the next great battle over American elections is headed. What makes this moment particularly significant is that the court took a narrower approach than it could have. The justices could have used this emergency application to issue a sweeping constitutional ruling settling every related question at once. They chose not to, and that choice is itself meaningful. Narrow rulings often serve a strategic purpose. Rather than resolving every issue immediately, the court sometimes allows legal questions to continue developing in lower courts, building more complete records, gathering more arguments, and ultimately giving the justices better information if and when these disputes return. Many experienced court watchers believe that is precisely what is happening here. The emergency stay addressed the immediate crisis, but the larger framework questions are still alive, still developing, and still likely to force a major reckoning sooner rather than later. And that is why, despite the celebration on one side and the outrage on the other, every serious observer of election law is treating this ruling as a beginning, not an ending. The constitutional architecture governing how America conducts its elections, who draws the lines, who has the authority to change the rules, and how close to a deadline courts can intervene, is being actively rebuilt in real time. The Supreme Court is the architect. And with each emergency order, each stay, each pointed rebuke to a lower court, the court is laying another brick in what may ultimately become a dramatically different legal structure than the one we have operated under for the past several decades. That is the real story, and it is only getting started.